Thank you. Good morning. My name is Felicia Orth, Hearing Officer for the Environmental Improvement Board. We're on day 3 of the hearing in the matter docketed as EIB24-49R. These relate to regional haze requirements. The hearing is very near its end at this point. I will invite public comment when we have finished with our final technical witness, Mr. Jewell. And we will also discuss the post-hearing timelines. We'll do that this morning as well. We have all of our board members. The hearing is being recorded and transcribed and also interpreted between English and Spanish. Ms. O'Grady, if you would, please.
Buenos días. Para cualquier persona que está en línea en la plataforma de Webex, si quieren escuchar al español, por favor miren en la esquina inferior a la izquierda y hagan clic en el globo, en el mundo. Cuando hagan clic en el mundo, entonces pueden escoger español.
Thank you very much. Let's see, when we broke last night, Ms. Wood was completing her questioning of Mr. Jewell. I think you had moved into what was effectively Sir rebuttal. All right. And if you'd like to re-ask the final question so he can give the complete answer we didn't have time for, that would be great.
Thank you, Madam Hearing Officer. I would like to say I'm joined up here with my co-counsel, Mr. Wexler, today, and my co-counsel, Ms. Bonson, is in the back. Mr. Jewell, before we had to adjourn last night, I had cited Mr. Jones's rebuttal testimony, which claims that your assertion about Q over D thresholds of greater than 5.6 that were adopted by other states is, quote, not supported by closer examination of other state SIPs. And then he provides several examples. My recollection is you had talked about a few of those states and had just finished describing South Dakota when we had to adjourn. Do you have any other states you would like to discuss?
Yes, I wanted to mention 3 others that Mr. Jones cites in his rebuttal testimony as supportive of the department's or NMED's Q over D threshold. One is Minnesota. I would say that Q over D analysis is hardly comparable because Minnesota considered emissions of not only NOx and SO2 in their Q quantification, but also of direct PM2.5 ammonia and VOC, rendering the 2 different Qs apples and oranges. As you may remember, NMED used only NOx and SO2. Secondly, Texas's source screening process was cited, also not comparable to NMED's. Texas used Q over D, but only as a secondary consideration for sources that fell within, again, they created an area of influence value for each class 1 area. I won't go into the details. Effectively, Texas did modeling as a part of their source screening analysis, modeling using photochemical grid modeling to supplement or together with the Q over D screening. And then lastly, Oklahoma, I just wanted to mention, it also does not rely exclusively on a Q over D threshold. It used the model that I mentioned yesterday with the extremely long name that's shortened to high split to sort of ameliorate issues with the sort of gross estimations that Q over D gives you.
Thank you, Mr. Jewell. Yesterday, when you were providing a summary of your direct testimony, I neglected to ask you to please describe EPA's SCR tool. Would you mind doing that now?
Sure, and just to quickly reiterate, the SCR tool is the tool that the department used to calculate the cost of SCR for Enterprise's Blanco C&D facility. And maybe the point to make and I believe it was in another witness's testimony, is the SCR tool within its own sort of user's guide or README file describes the types of sources that it is intended to apply to. And those, I could go through the details, it's in my direct testimony. Effectively, it's large utility and industrial boilers. Neither sort of engine, a reciprocating internal combustion engine or a turbine, are mentioned in the tool at all, and therefore the units at Blanco, there would need to be a justification for using that tool as applicable to the units at Blanco, since the tool itself doesn't suggest that it would be done so.
Thank you. Returning to Mr. Jones's rebuttal testimony, he takes issue with your comparison to Arizona, noting that Arizona's SIP, quote, was partially disapproved by EPA due to deficiencies in its source selection methodology, close quote. Is that an accurate characterization of Arizona's SIP partial disapproval?
No, I don't think it is. I think it's a little misleading because within EPA's proposed rule, they state precisely why they disapproved Arizona's long-term strategy. And it further says that it actually agreed with Arizona's Q over D threshold, which was 10. Just a quick quote, we, EPA, found that ADEQ reasonably and adequately explained and documented many aspects of its source selection process. And it goes on to say, including the use of a Q over D value of 10 for point sources.
Do you have a citation to that quotation?
Yes, I do. It is, excuse me. Yeah, Federal Register, volume 89, page 102758.
Thank you. Turning to Mr. Miller's rebuttal testimony, he claims you argue that NMED did not consider visibility at all. Is that in fact what you are saying?
It is not what I intended to say at all, actually. In fact, as he further explains how visibility was used and should be used, I actually agree with most of Mr. Miller's rebuttal testimony there, but I do feel like my statements were taken out of context. Just to summarize, my testimony is essentially summarized in one agreed upon statement that NMED made, that it did not directly consider visibility benefits of potential control measures when making control determinations.
And what is your position on that position by NMED?
So it seems reasonable to me that in a rule with the stated national goal of achieving reasonable progress of visibility conditions in Class 1 areas, the visibility should be at least considered in some way when
Did
making.
you mean to just say that that was reasonable?
Yes. What did I say? Yeah, no, I think it would be reasonable to consider visibility when making visibility rulings.
So just to clarify, NMED's position that you don't need to consider that, what is your assessment of that?
Excuse me.
Do you think it's reasonable that NMED is not considering that?
No, in my opinion, it is not reasonable to not consider visibility when making literally millions of dollars worth of control decisions within the context of a rule that whose only goal is to improve visibility.
Thank you. In Mr. Miller's rebuttal testimony and in his testimony on Monday, he accused you of cherry picking examples of states that did consider visibility when making control decisions. Would you like to respond to this accusation?
Sure. Just with regard to the cherry picking accusation, Mr. Miller provides his own list of examples. We're both providing examples for informational purposes. I was providing examples of the different ways in which other states have considered visibility. And actually, it should be noted that one of the states that Mr. Miller lists is Arizona as a state that did not consider visibility. But the state apparently did consider visibility for at least one facility. EPA says so in its proposed approval of the Arizona SIP, the facility being the SGS units 1 and 2. It discusses a visibility benefits of potential controls at that facility on those units.
Thank you. After providing the list of states, Mr. Miller then explains that, quote, EPA has made clear that rejecting controls found to be reasonable and cost effective based on the 4 statutory factors because they would not produce perceptible visibility improvements is inconsistent with both the Clean Air Act and the Regional Haze Rule. Do you disagree with that?
I would say that the statement is true, but it's a bit of a red herring because I made no claim about perceptibility of visibility impacts. I have not claimed that perceptible visibility improvements would have to be demonstrated in order to justify controls. I've only pointed out that NMED did no demonstration of how its controls decisions would or would not lead to any visibility improvements.
In his rebuttal testimony, Mr. Miller said that, quote, given the NMED determined there are reasonable and cost-effective controls for many of the units it evaluated, it is not clear what would be gained by considering the visibility benefits of those controls if rejecting them because they might not produce perceptible visibility improvements would cause EPA to disapprove New Mexico's SIP. Would you like to respond to the statement?
Yes, I would say there are multiple issues here. I'll try to be brief. First, I would ask, are the controls truly reasonable if they do not help improve visibility in Class 1 areas, the ultimate goal of the program? Second, I think what would be gained is an understanding of whether these expensive controls are predicted to actually achieve the goal being sought by the program. And then third, and again, I've made no testimony about perceptibility or any other specific level of visibility improvement. And then lastly, I might just ask, if NMED's only goal is to have EPA approve the SIP, then I wonder why go to the trouble of creating one in the first place rather than just letting EPA issue a FIP in their timing.
In Mr. Miller's rebuttal testimony, he claims that you stated, quote, that the required emissions reductions at the 3 enterprise facilities are not necessary to fulfill regional haze requirements and will not result in visibility improvements at the closest Class 1 areas. Would you like to respond to this claim?
Yes, I made no such statement. My testimony, again, is primarily about the department's lack of demonstration in the record that controlling the enterprise facilities will move any of the Class 1 areas closer to the national goal. Specifically, my testimony stated that the record does not establish that regulating the enterprise facilities will result in visibility improvements. I also said that NMED does not appear to have taken any of these, and I'm referring to the URP issues there, any of these considerations into account. And also said, without further evidence, these facts, and in that case, I'm referring to the windrows discussed earlier, they provide a basis for concluding that emissions controls at the enterprise facilities will have minimal impacts at the Class 1 areas. NMED has, in my opinion, not addressed any of the evidence in this record, any of the evidence I just mentioned in the record. I'll finish. None of these statements conclude that there will be no visibility improvements from the enterprise facilities. Rather, these statements are intended to just make clear that we do not know whether the proposed controls will result in visibility improvements.
Thank you. In his rebuttal testimony, Mr. Miller claims that you are testifying that NMED's CETV is unreasonable because it is higher than the CETV used by many other states. Is that a fair characterization of your testimony?
No, my testimony compares NMED's CETV to those adopted by other states, but it primarily points to NMED's own binning analysis as the reason to question the reasonableness of its selected threshold.
With regard to your testimony regarding NMED's CETV selection, Mr. Miller also accuses you of cherry picking states with higher values. Would you like to respond to this accusation?
Yes, again, we both provided lists of example states with different values. I made no claim that NMED should adopt a particular value based on what another state has done.
Also, with regard to your testimony regarding CETV, Mr. Miller states that, quote, your assertion that NMED's use of a bright line cost threshold was somehow inconsistent with the regional Hayes rule because that is somehow inconsistent with the regional Hayes rule is baseless, close quote. Is that what you are claiming?
No, my statement was about how the singular CETV value is blind to the site-specific nature that a four-factor analysis is supposed to have. I was not claiming that picking a single CET value is actually inconsistent with the regional Hayes rule, but there are other options. So my testimony is that setting a single value that applies to all industries, all pollutants across the state lacks consideration that different industries can afford different cost effectiveness values. Not all pollutants are equally effective at generating visibility impairment or improvement. And distance to class 1 area, topography, all the things that go into modeling should matter when the overarching goal is to reduce visibility impairment in class 1 areas. And I'll just mention one example that I thought was interesting, and it has been adopted by a number of states. Arkansas was the first to do it. They actually established, I believe, 4 different CETV values based on different industries were represented within the state. They range from approximately $1,000 per ton to $5,000 per ton.
Thank you. In his rebuttal testimony and on Monday in his testimony, Mr. Miller relied numerous times on EPA's statement in its 2021 clarification memorandum that the uniform of progress is not a quote safe harbor close quote to preclude sources from control requirements. Does this statement remain EPA's policy?
Actually, no, that policy recently changed in an announcement on April 18th, 2025. EPA said, and I'll quote, the EPA is announcing that it is the agency's new policy that where visibility conditions for a class 1 area impacted by a state are below the URP, and the state has considered the 4 statutory factors, the state will have presumptively demonstrated reasonable progress for the second planning period for that area, end quote. That comes, that statement about policy comes from within an EPA proposed approval of the SIP for the state of West Virginia. That was again published on April 18th.
And was that a regional Hayes SIP?
It was a regional Hayes SIP, yes.
And can you provide the citation to that Federal Register notice?
Yes, I can. Federal Register, volume 90, page 16478.
And what page was your quotation from?
I believe that's the page that my quotation is from.
Okay. Would this new policy support a decision by NMED that no controls are needed to address regional Hayes in New Mexico?
Yes, it seems that it would.
Thank you for your testimony today and yesterday, Mr. Jewell. Before I open you up for cross-examination, do you have a recommendation for the board?
Yes, so I would recommend that the board not approve the draft SIP as written, send it back to NMED to correct the deficiencies that I've identified and conduct the required analysis to be sure that the controls called for in the draft SIP are in fact justified as reasonable under the Regional Hayes program.
And right before we go to cross-examination, the page number of the quote from that Federal Register, is it actually page 16483?
Yes, it looks like it is. Thank you. The page number I gave is probably the first page of that notice.
Thank you, Mr. Jewell. We're ready for cross-examination now. Sir.
Thank you, Ms. Wood and Mr. Jewell. Mr. Behill, do you have questions of Mr. Jewell?
Mr. Jewell, hope you're doing okay.
Yes, thank you.
Doing a lot of talking. You mentioned a recent change in policy regarding the uniform rate of progress, and you made the claim that the policy had changed on April 18th. Isn't it true that this is just a policy recommendation?
Yeah, that's what EPA said. It was a change in policy for them.
Isn't it more accurately characterized as a proposed change in policy?
The statement says it is their new policy.
Mm-hmm. And to your knowledge, has it been adopted yet?
Well, considering it's a policy, I don't think it goes through normal like public comment or rulemaking. It's a policy statement.
I see. I see. And okay, so if this policy has been proposed in the Federal Register, and let's just say it's for sake of argument that it's subject to public comment, which is often the purpose of the Federal Register, before it's adopted, wouldn't you say that the prior policy is still in effect?
Objection calls for a legal conclusion.
So, Mr. Jewell, the usual instruction, if you have an understanding, given your role for the company, you can answer, but not as a lawyer.
Yeah, of course. I would say, in my experience, once EPA makes a policy statement, we consider it effective immediately, regardless of the context that the statement is made in.
Okay, thank you. No further questions.
Thank you, Mr. Vihel. Ms. O'Grady? Mr. Harris? Thank you. Both Ms. O'Grady and Mr. Harris said no questions. Let's see, Ms. Gutierrez, you may be on the platform this morning.
I'm on the platform and no questions from me. Thank you.
Thank you. Ms. Catalano? Okay. Now we turn to the board, unless you have a redirect you'd like to ask right now.
Just one very quick redirect. Mr. Jewell, does EPA ask for comment on the new policy?
I don't recall them asking for comment on that policy statement.
Thank you.
Okay. Let's turn to the board. Would you like to start this morning, Vice Chair?
No, I don't have any questions this time, but I could follow up at the end, maybe.
Absolutely. Let's see, Member Bitzer.
No questions.
All right, Member Garcia.
Thank you, Madam Hearing Officer. Just one question. Sir, you do have a fair amount of knowledge about the EPA guidelines and requirements, et cetera. And one of the things that I'm curious about is NMED stated several times that they've been in close contact with EPA regarding their approach to these facilities and using the guidelines, et cetera, because they stated they want to make sure that when they do submit the SIP for approval, assuming we were to adopt it, then they don't want a lot of questions and comments. They want to make sure it's ready for EPA approval. So you brought up lots of concerns that NMED did not follow proper protocols and the various premises they used for calculations, et cetera, were incorrect. If these were shared with EPA, I'm wondering what your position is. Do you feel that EPA has not had a chance to look at what they've done? Do you understand where I'm headed here?
I understand that question, and I couldn't say what the consultation with EPA has been with the department. I don't know. I would presume that there's been lots of consultation.
Okay. Thank you.
You're welcome.
Thank you. Let's see, on the platform, I see Member Ely. Like to go first?
Yes. Good morning, Mr. Jewell. Just a couple questions about the 3 facilities. Yesterday I was a little confused about the controls at each of those because I was looking at the 2024 draft SIP, not the 2025 draft SIP, and it got me looking at the changes between those two. between Exhibit 1 and Exhibit 5. And I noted that for South Carlsbad, that NMED originally proposed emission caps based on SCR and then changed it to DLN. And that Trinity did a 4-factor analysis there and demonstrated that the DLN caps based on DLN would be at or below the $10,000 threshold. So 2 questions. One, why the change? Was it because of your 4-factor analysis? And then you're opposing, I think, the DLN, the emission caps based on DLN. And I'd just like you to reiterate why.
So why the department made the change between the two draft SIPs, I couldn't say. I know that it caused some consternation on my part with reviews, but I couldn't say why that was done. The second question, could you repeat? It was about South Carlsbad and DLN.
Yeah, it looks like your 4-factor analysis established that DLN controls would be very close or below the $10,000 threshold proposed by the department, but yet you still have concerns with those caps. And I'm wondering, is it because you don't support that threshold? You don't, the CETV is you think is just too high?
Yes, that's essentially it. The cost per ton values that we submitted as a part of the 4-factor analysis, we view as economically infeasible, despite the department's adoption of a $10,000 per ton CETV. So it's effectively a disagreement with that threshold.
Okay. All right. So you don't know why, it just seems like quite a concession to go from SCR to DLN, but it wasn't based on information that you submitted.
It may have been. I don't know why that decision was made.
Okay. And then at Chaco, they originally proposed SCR on units on the turbines 35, turbine 36, and 37, and then struck it completely. So it's the same question there. Was it based on consideration of cost or room, or inadequate space at the Chaco facility? Was that why they struck those?
Objection. I'm not sure that, Mr. Jewell is in a position to be able to testify as to why the NMED made changes between the 2024 draft SIP and the 2025 one. I mean, he can speculate, but that's what it would be.
All right. So, Mr. Joel, the usual instruction, if you don't know, you are certainly invited to say you don't know.
Yeah, so I don't know directly. I would add that it was space constraints that were the cause for Enterprise to make the claim that SCR was not feasible in that case. But I do not know why NMED made the same decision.
Okay, so it wasn't that you submitted data and they said, "Oh yeah, you're right. Let us delete that from the current version of the SIP."
That could have been the case, but I do not know.
Okay. And then let's see. I have one more question, but hearing officer, maybe move on while I find it. Thank you.
All righty. Member Honker, do you have any questions for Mr. Jewell?
No questions, thanks.
All right. Madam Chair, do you have questions of Mr. Jewell?
Good morning, Madam Hearing Officer. I don't have any questions at this time.
All right. Vice Chair Trujillo.
No.
Nope.
So back to Member Ely. Okay, sorry, Member Ely, putting you back on the spot.
Sorry, I found it. So on the facility-wide averaging that you're proposing for Blanco and South Carlsbad, do you know when this proposal was brought to the department?
I don't. I wasn't a part of developing that proposal. That was Mr. Jacobson's testimony. So I don't know.
Okay, thank you. That's all.
All right, thank you. Does that raise any further redirect for you, Ms. Wood?
No, it doesn't.
All right, any reason not to excuse Mr. Jewell then? No, thank you very much, Mr. Jewell, for your testimony. Let me ask if there's anyone on the platform who would like to, who has not already provided public comment and would like to offer a public comment at this time. This will definitely be the final opportunity to do that. Okay.
Yeah, no one has indicated, although briefly, Ms. Gutierrez's hand was up. She might have a comment. Anna Gutierrez?
Oh, Ms. Gutierrez, do you have something to say?
Yeah, sorry, I took my hand back down because this is not public comment. Just wanted to follow up on our testimony yesterday. Closing the loop, as you know, we presented slide decks in our testimony, and I did not take the opportunity to request those be admitted into the record, and wanted to do that now.
Yes, thank you. Do I hear any objections? I will say that with the board members, we're definitely interested in having those. Okay, thank you. I see no objections, Ms. Gutierrez. Thank you for uploading those. Let's see, anything, okay, so we didn't have any public commenters on the platform. I don't see anyone in the room who's not affiliated with a party. So we can.
Madam Hearing Officer,
yes,
I'm
Ms.
sorry to interrupt you. Sitting here with me is Mr. Kraft, who's in the General Counsel's office for Enterprise. And he came up and he may be able to answer some of those questions that member Ely had. And they'd be willing to do it in writing, or he could do it right now. I know if that would be.
Okay, so I think that would be in the nature of legal argument, yes?
I know it would just be, she had asked some questions that Mr. Jewell was unable to answer regarding things like when was the alternative regulatory language on, things like that proposed.
Okay, because we're going to talk about closing argument as a separate matter. Are there objections to hearing from Mr. Kraft to respond just to member Ely's questions? All right, Mr. Behill indicated he had no objection. I don't hear an objection from anyone else. Mr. Kraft, if you would. I'm sorry. Yeah, I will. Mr. Kraft, would you spell your first and last name for the transcript?
Good morning. Zachary, Zachary. Last name Kraft, Craft.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Ms. Wood.
I'm making Mr. Kraft available for questions from the board.
All right. Member Ely, would you like to repeat your question to Mr. Kraft?
Yeah, I think it's just related to the timing of the proposal for site-wide emission caps for Blanco and Carlsbad. Mr. Kraft, can you tell me when that occurred?
I can, Member Ely, and thank you for the question. Most specifically, as you might recall from the testimony yesterday, Enterprise became aware of the proposed control limits in the August 2024 SIP. At that time, we submitted public comments in September of 2024 that were rather lengthy, but among other things requested site-wide capped limits. So that was the first time we made the request. And as you pointed out in one of your questions, Member Ely, that draft SIP imposed SCR controls on multiple Enterprise facilities. The revised draft SIP that was issued by the NMED on or about December 13th, 2024 made some control changes, as I think you noted in your remarks. We did file comments on that revised draft SIP in early January 2025, and at that time repeated our request for capped limits. So those were the two occasions in which I recall us making that request.
Thank you. That's helpful.
All right. Let me just open it up generally. Please indicate if you have a question, Mr. Kraft, while we have him here. Oh. All right. Thank you very much, Mr. Kraft. Thank you, Ms. Wood. Okay. So we have no indications that anyone desires to offer public comment. We have finished with the technical witnesses. We are receiving the slide presentations from EPNG. Any reason not to close the evidentiary record at this time, Mr. Behill?
I didn't, I was just getting up to prepare to speak. I didn't mean to interrupt you.
Okay. So the evidentiary record is closed. We'll talk now about the post-hearing process. The first decision would be whether the board wanted to deliberate immediately following the close of the record. My understanding is that they would like to deliberate after the transcript is received and written closing argument is received, and a brief report from me. Mr. Behill, I want you to assume that the court reporter has indicated he would have the transcript ready by next week. Do you have a proposal as to when the parties would submit their closing argument?
Yes, thank you, Madam Mayor, Officer, Madam Chair, members of the board. I conferred with the counsel for the other parties, and we have agreed that what we are asking is that written closing arguments, proposed findings of fact, and conclusions of law be submitted 90 days after we receive the transcript. Excuse me.
Okay, so let's see. Let's assume we'll have the transcript by May 5th, for example. June, July, August. Let me ask Pam to speak to upcoming matters that would have the board in long meetings so that we avoid putting deliberations on top of that. Pam, is there anything that the board is doing that's lengthy in August?
Stand by while I check the calendar. I don't think so. It would be on that paper calendar you've got there, but let me just look. I don't see anything.
Okay.
Let me just note that Ms. Gutierrez has her hand up again.
Oh, Ms. Gutierrez.
Thank you. And this is no objection to the timeline proposed by Mr. Behill, but I do want to request clarification on scope of what is appropriate in those briefings. And I can take that now or take that after we set the timetable.
Yeah, so well, I can answer it now. It is discretionary with the parties as to what you would like to submit. Sometimes parties choose to submit just written closing argument, what they would be saying in a verbal closing argument, and it's in writing instead. Sometimes, particularly those parties who, for example, have put on lots of witnesses or put in lots of exhibits, are also interested in providing proposed findings of fact or conclusions of law that could be incorporated into a statement of reasons, because in New Mexico, every action taken by the board has to be supported by pretty specific and often lengthy statement of reasons, so that on review by the appellate courts, they know exactly why the board made the decisions they made. But it's up to each party. No one is required to submit anything.
Understood. And I have a specific question for hearing officer and a request, if you will. So we addressed, our witnesses addressed the infeasibility of the replacement project at Blanco A in our direct witness testimony. It was not rebutted by the department in its rebuttal testimony. They have, in our opinion, waived that opportunity. So the request is that any subsequent briefing by them related to the factual basis of infeasibility would be both unfair surprise, and we would not have an opportunity to respond. It is our position that factual basis from the department would be impermissible in their post briefing. If the department wanted to brief the legal question of whether it's permissible to require an infeasible project, we would not object to that.
Okay, so again, the evidentiary record is closed and no new evidence, that is to say, no new factual evidence would be welcome in a post-hearing submittal. As to any arguments based on the evidence that is in the record, it's what the parties choose to do.
Thank you. I think that clarification is helpful.
All right. Let's go back to the time.
Madam Hearing Officer.
Mr. Behel.
Oh, sorry. What I wanted to offer to Ms. Gutierrez is if she goes to the Roper matter, if she goes to NMED's Docketed Matters website under the Environmental Improvement Board, there's a case called Roper, and there's a number of findings of fact and conclusions of law closing arguments from NMED and private parties that she might find helpful in terms of like looking at the scope of what might be covered.
Thank you, Mr. Behel. And I seem to remember Ms. Gutierrez was also in the ozone precursor matter. Is that correct? So I believe you've seen those kind of documents there.
That's correct, Madam Hearing Officer. And I was really just speaking up to make the point of scope of the department's post-hearing briefings as it relates to the Blanco infeasibility and the limitation on additional facts there.
Okay.
Thank you.
So let's say effectively that the parties would have the month of May, the month of June, and the month of July here. I think I would choose August 1st as a date for submittal because that would allow the board to deliberate at their August 22nd meeting or at their September 26th meeting. I think at this point, Madam Chair, I'm going to turn the discussion over to you because my role is done. We're not hearing closing arguments today, and I'm looking at Pam's board calendar. I'm not seeing lengthy hearings for you in August or September.
Thank you, Madam Hearing Officer. And I just want to thank you for your work on this hearing and guiding all the parties and all the information through the process so that the board can have the comprehensive resources to review as part of this record. So just want to thank you for your help with this hearing, Madam Hearing Officer. With that, I'm looking at my calendar as well here. So given those timelines, fellow board members, as Madam Hearing Officer was mentioning, we're looking at August 22nd or into September. Do you see any, foresee anything that mine looks clear that we could probably deliberate in those days? Yes, Member Ely?
Yeah, I'll be out the second half of August. The September date is open.
Okay, thank you so much, Member Ely and Member Honker.
Yes, I have a conflict with the the August 22nd date, but the September date is clear on my calendar as well.
Okay. And members of the board there at the State Capitol, room 321, do you have any constraints or considerations?
I'm going to be in Africa late September. Maybe I can get online. I don't know, depending on being Cape Town, I think, at that point. So get chased by sharks.
And when Member Bitzer, when do you leave for your trip?
I want to say it was the 18th. But I'll have to double check on that. I know I'm out late September.
Okay. Thank you for that. Any other board members there in the in room 321? Looking good. Member Garcia?
Yes, I'm clear September, so that works.
Okay, and Vice Chair Trujillo?
My life is not as exciting as everybody else's. I've got nothing going on. So I do propose though that maybe if it makes it easier if we shift our normal meeting within August or September, either maybe earlier to help accommodate.
Sure. So fellow board members, I know Member Hunker, Member Ely, you had some constraints at the end of August. How about early September? Do you have any other calendar constraints?
Yeah, I've got a big trip planned between mid-August and mid-September. So
Okay.
the end of September or the beginning of August, perfect.
Okay, end of September, beginning, but we won't be getting the hearing record. All the submittals are due, I believe, Madam Hearing Officer, you said August 1st?
Yes, that gives them very close to 90 days that's requested.
Okay.
Do we go to October?
Hold on one second, Ms. Catalano, you have a question?
Yes, thank you, Madam Hearing Officer. I just had a question. Namoga was planning to submit a written comment to the board. Would it be possible for that to be done before 5 p.m. today?
Oh, yeah, so I spoke the words that the record is closed, but if you can get something today, that would be fine.
Thank you very much.
You get it to Pam. All right. Sorry, back to you, Madam Chair. I know you can't see what was happening in the middle of the room there. So someone just asked about October.
Madam
Yes,
Chair,
yes.
is there any are we required to deliberate within a certain time frame of the August 1st date?
I believe there is some time constraints. Either legal counsel or Madam Hearing Officer, if you could chime in on that.
Yeah, is Mr. Ugarte on the platform?
He is. I saw his name. Legal counsel Ugarte, are you there?
You have an answer. And Mr. Rehill has approached the table. Let's see if Mr. Rehill has something to offer.
Thank you.
Thank you, Madam Hearing Officer, Madam Chair, members of the board. Unless the other parties object, it would seem to me that because we proposed and agreed to the timeline, that the parties would essentially have waived their right to challenge any sort of deadline with regard to a decision.
It would be hard to bring a mandamus in that landscape, wouldn't it? All right, back to you, Madam Chair, and Mr. Ugarte.
Thank you so much. Mr. Ugarte, are you there? I don't see. Oh, there he is. Do you have anything to share, Mr. Ugarte? No, you're muted. There you are.
Sorry, I was trying to unmute. Okay. Madam Chair, no, I think Mr. Behila is correct. Given the stance of the parties, there isn't the normal time restriction.
Thank you, Legal Counsel Ugarte. Appreciate that. So with that, board, did you want to look into October then? How do your schedules look in October?
Open for me.
Okay, and Member
So-
Hunker?
Yes, I'm clear.
Okay, I'll look to those in room, board members in room 321. Vice Chair Trujillo, does that look good to you?
Yes, October's good for me.
Member Bitzer? All right,
All
and
good.
Member Garcia?
Yes, October 24th would be the date, and that's fine with me.
Wonderful. All right, so it looks like October 24th is good with our board. And so we'll plan for that. I'll mark it on my calendar right now. And looking forward to that. Madam Hearing Officer, is there anything else that I think we need that the board will need to chime in about?
Actually, no, I don't believe so. Let me just adjust in a very minor way what I said earlier. Instead of just landing on August 1st as the date, what with the deliberations being out in October, I think I will enter an order just saying you have 90 days from the date of the transcript. Whenever that is, it'll probably be a little later in the first week of August. And I will also then have an opportunity to submit a report to the board. And again, it will be a short report. We won't include any recommendations, but I'll do what I can to tee things up for your decision making.
Thank you, Madam Hearing Officer.
So is there anything else we should cover before we adjourn? All right. Thank you all very much. Thank you, Madam Chair.
Thank you. Thank you, everybody.